Thank you very much for taking the time out of your busy days to join this lunchtime webinar. I can see people are still joining, but it's about 1:05 now, so I think we'll start. I'm Mai-Ling Savage. I'm a member of the family team and also court protection team. Speaking today, we've also got Amanda Weston, QC, who has recently, as you just said, spent 6 weeks preparing the submissions in RE-T that went to the Supreme Court, was heard in the Supreme Court at the end of last month, and that grapples with the issues that we're talking about today, which are Section 25, secure accommodation, the inherent jurisdiction, and the tension that has with the child's Article 5 rights. We're also really grateful today to have Hilke Holman from Freeman's also speaking with us. She's a partner at Freeman's. She's an extremely experienced lawyer who no doubt many of you will be familiar with, and has a lot of experience in this area representing children. So without further delay, I'm going to now try and do what I was failing miserably doing before, which is to share my screen. And here we are. I just want to move this. Just bear with me a moment whilst I can see. That doesn't really help. Apologies, I just want to make sure that I can actually see what I'm saying. Great. So what the situation that no doubt many of you will have been faced with is that there is a crisis in secure accommodation. And we can see from this passage from Holman's judgment in AT and FE that this situation isn't new. It's certainly, and I've listed a number of cases at the end of the slideshow that show that this is a situation that's been enduring for quite some time and isn't just as a result of the current situations that we face in the pandemic, but also it's been going on for a considerable length of time. And the reason why we thought this topic was an important one to deal with is because what's becoming more and more apparent is that there's the Section 25 statutory regime, but also running alongside that, running along parallel to that, is this subset of cases which where there is no accommodation, no approved secure accommodation, and local authorities are being faced with a situation where they've got to take matters to the High Court to have those placements sanctioned under the inherent jurisdiction. And so the issue being that these, by the very nature of the placements, these children are some of the most vulnerable children in the care system. And there is a real risk that they are not receiving the same sorts of protection that would be afforded them through the statutory scheme. And that in terms of, and this is an issue that Amanda will deal with, in terms of their deprivation of liberty, consent and competence to consent to their detention, which is an issue that came up in RE-T, that those issues create that additional aspect to these particular subset of cases. So looking at the Section 25 criteria, under the Children Act, the local authorities, and certainly from my experience of practice, when I first started in practice, the young people that were being placed in secure accommodation were really young people who had a series of failed foster placements and were putting themselves in pretty risky situations, and their behaviour was unable to be managed, either in foster placements or in residential settings. The type of cases that we're seeing now, certainly the 20 years that I've been in practice, have significantly changed, in that young people at risk of child sexual exploitation, more recently cases involving county lines, and then also those cases which don't, where capacity isn't an issue, where young people are falling slightly sort of short of falling into issues to do with sort of detention in psychiatric services, but are still at risk, significant risk of self-harm. So those are the type of, and I'm sure that from your own practices, you'll know that those are the type of young people that are facing detention under section 20, traditionally under section 25. Now, the definition of secure accommodation, of course, this is where the issue is when there's a shortage of secure accommodation, is accommodation restricting liberty. And the section 25 itself doesn't actually provide that the Secretary of State must approve those placements, but it's the regulations. So it's not the Children Act itself, but it's the regulations in terms of secure accommodation. And Regulation 3 sets out that it has to be approved by the Secretary of State. And it's that issue and the shortage of those type of placements, which courts, and really it's reached the highest sort of level of judiciary, have been commenting on consistently, that there just aren't enough of these places. Now, I wanted to look at, I apologise, I haven't put the full reference in that heading, but that's Re B. And that was a decision of the Court of Appeal from Baker's decision. And he deals there with 4 important points in terms of what the meaning of secure accommodation is, the relevant criteria for making a secure accommodation order under section 25, and the importance of welfare decision and the paramountcy of welfare decision. And fourthly, when considering, and this is the point that Amanda's going to deal with, the issues under Article 5 and under Article 8. Now, in Re D, which is a decision that many of you, of course, will be familiar with, I've quoted that bit there from Lady Justice Black's obiter comments in Re D, because what she says there is that she was, although in Re D that was a case where the issue of capacity was the central part of that decision, and whether or not that young man was able to, the sort of zone of parental responsibility was a major part of that decision. Lady Justice Black did make these obiter comments about section 25, and although that wasn't the main part of that decision, she does make those points about it, and goes on to really explore what section accommodation under section 25 means. And she posited, although she didn't deal with fully, she posited as to whether or not actually local authorities, when they're placing children in, whether psychiatric units and other types of placements could be interpreted, giving a wider interpretation to section 25. And so she says there that when there's much force in what was upon which the accommodation itself is in the spotlight term, determining whether particular accommodation is secure accommodation, and that interchange between what the dealing with it on a case-by-case basis and looking at the individual children's needs within those placements. And so when Baker deals with that, he agrees with what Lady Black says in her observations in Re D. And he says there that, hold on, I've just got to move my so I can read it. Secure accommodation is accommodation designed for, having as its primary purpose the restriction of liberty. As Mr. Justice Wall acknowledged, however, the premises which are not designed as secure accommodation may become secure accommodation because of the use to which they have been put in particular circumstances of the individual case. And that's important to remember when dealing with these cases. Now, moving on to the relevant criteria. Those are ones I won't go into detail because those are issues which we'll all have been familiar with, and they haven't really changed. What's interesting is the sort of mandatory nature of Section 25, though, in that it must make, it shall make an order authorising. So once the court has considered the Section 25 criteria and finds that the child has met the Section 25 criteria, it shall make an order authorising the child to be kept. And that's an interesting feature of Section 25. And then thirdly, the issue about welfare. And the interesting point about Section 25 is that welfare isn't dealt with as the primary sorry, just going back. So that was considered in, the issue about welfare was considered in Re-M. And in terms of welfare, it is of course important, but it isn't it doesn't get the same, allows the local authority to exercise its power. Welfare is an important factor, but it isn't, it's not paramount, but it's plainly an important element in terms of the court's analysis, and it is one of the relevant criteria. So after that decision of Baker, we see in Re-T what the President, when he heard that case, did was the concern about the inherent jurisdiction really cutting across that statutory scheme and allowing for what are essentially placements which are not regulated in the same way. But there was no argument in Re-T at that point when the President heard it about whether or not the inherent jurisdiction, whether the legitimacy of the placements under the inherent jurisdiction for children when there was no secure accommodation available, which then led the President to publish the guidance in November 2019. And the guidance is really essential reading. It's extremely important to look at that guidance because it sets out there when applications are made to the High Court under the inherent jurisdiction to authorise placements that are not approved by the Secretary of State, that are regulated placements, essentially, what the review has to be by the court when the application is being made. And I'm going to try and get that guidance up if I can manage that. I don't know whether to. I'm not sure I can manage that actually. Hold on, I think I can. No, I don't know whether, can everyone see that? Great, I did it. Even without my glasses. I had a slight problem, I've lost my glasses. So this is the guidance that the President produced after he heard Re-T. And the primary focus of the guidance was to ensure that when the court authorises a placement in an unregistered unit, what steps should be immediately taken. And if you find yourself in a case where the local authority are seeking court's authorisation for an unregistered placement and seeking to have permission to deprive a child of its liberty in by way of the inherent jurisdiction, these are the steps that the court has to take, and they are. There are 4 steps which start at, here we are, this is the best practice. So in terms of the local authority, when it makes its application, has to inform the court as to confirmation about the registration status. Then looking at, if it's not registered, is registration required? And if registration is required, for the local authority really to keep these steps constantly under review, there's a great onus on the local authority in these cases to ensure that absolutely everything is being done to ensure that if it can be a registered placement, it is. And the court monitoring that application and reviewing the placement. And really, when there are these placements that are in unregulated units, the court must keep the matter under constant review. And those are the 4 steps that the court must take when there are applications under the inherent jurisdiction. So I'm going to go back to the slides now. Let's see if I can do that. So those were some of the issues in respect of the inherent jurisdiction. But I wanted to look at one particular case, which was a case that was heard by Mr. Justice Cobb, Re S. Now, in that case, a young woman who had local authority become involved because of issues to do with concerns of about her assaulting her parents. She then went into foster care. The foster player, it was a very familiar sort of story where the foster placements broke down, and then a number of residential placements broke down. And then the local authority found itself in a situation where it couldn't find a residential unit to take this young person. And when I was reading it, it reminded me of a case that I had done where there was a similar situation where a young person sort of run through all of the available options, and then the local authority couldn't find a placement for this young woman. And what would happen was, in that intervening period where there was no available placement for her, she'd spent 4 nights in a police cell because she'd been arrested and spent the night in police cell, released, arrested, and then released, arrested, and then released. And there was, the local authority were constantly searching for a placement, but unable to do so. And what they were being told was that she was too challenging for the approved secure units. And really, it seemed that there was, if there wasn't a placement for her in units that were designed to accommodate the most vulnerable children, really, where was she going to be placed? And a lot of the reluctance from the care providers seemed to be about when speaking to them, social workers were saying that they seemed to be very concerned about their Ofsted rating and felt that they couldn't accommodate her because she was too much of a risk because of the impact that she'd had on other residents in the residential units, because she had effectively caused quite an amount of disturbance and encouraged other young people to join in the disturbances. And so they were concerned that she'd do the same in the secure units. That would affect their Ofsted rating. And of course, once an Ofsted rating, because from speaking to the secure units, once there's a serious incident where the police are called or where there's a young person that has harmed other people, and the Ofsted immediately come and re-inspect, and that can result in a downgrading of their status from either good to requiring improvement. And once that, and we all know that in terms of schools or residential homes or children's homes or secure units, local authorities then are not permitted to place without special authorisation. And that can lead to residential units essentially having young people removed from their placements and then not being able to function. So that's one of the reasons, it seems to me, that a number of secure units are often unwilling to take young people who've got a very particularly challenging behaviour. So this young person found herself in a holiday cottage. And it's an interesting judgment to read, because what Cobb does then is he goes through the statistics and finds that there's this sort of chronic shortage of secure accommodation. And there was this increasing disparity between the number of approved secure accommodation placements and the resources available to local authorities. And he sets out there in that judgment the figures, and I won't take you through them, but it certainly makes an interesting read in respect of that. And it was coming increasingly, and that's again sets out really that judgment from Cobb really crystallises a lot of the concerns of the judiciary in terms of the availability of these type of placements. And there at the end there, I just set out the number of cases recently that have dealt with this very issue. And I think the string of cases really shows that what an increasing problem this causes. And although in Re T, the president didn't, and as I say, it wasn't taken as a point as to whether or not the availability of the inherent jurisdiction for the authorisation of unregistered placements. It's a case, and I didn't set it out in the talk, but it's a case where Lord Sumption, and it's case Re B in 2016. And Lord Sumption gave part of the dissenting judgment in that case, because he was concerned that when cases are approved, when sanctions given to local authorities to place children in unregulated placements, those children are being deprived of their liberty without the degree of protection afforded that was really, and is set out in section 25, and it cuts across children's rights under section 25 in terms of the statutory framework, because there is no statutory framework for these type of placements. And there have been increasing concerns about the skill and training of the members of staff that are looking after children in a number of different scenarios. I've had cases where it's been hotel rooms, rented accommodation, and a number of really not accommodation that's really suitable for the most vulnerable children that we have. And so for that reason, as I say, in this particular subset of cases, the lack of scrutiny, and that's why, in terms of the President's guidance, that guidance has to be adhered to so stringently, because the constant review of the court is the only way those placements can be.
I see we've had our first comment in, and I was thinking whether there was a tent on a holiday park and a narrowboat as well.
Yes,
I had children who were running county lines and running away from gangs in London, being placed on a narrowboat, which was so cold that they lasted a day, and then they ended up in a caravan. So I think it's a real problem, and we don't have a resolution for it. So we continue to use a plaster to deal with the shortage of places, and also the the massive difficulty of finding secure places for particularly challenging young people. And what do you do if you can't find anywhere? And that's not going to go away anytime soon. So I think it's an ongoing problem and an ongoing discussion.
One of course, the other issues available to local authorities is it's really about the location as well, because oftentimes if there is a secure placement available, it's very, very far away. If you're in London, it's often hundreds of miles away, and in fact local authorities have resorted to placements in Scotland as well. And the case of Salford City Council and sets out the process for approving a secure placement in Scotland, and I include that there to set out what route the local authority should take if it's a placement out of the jurisdiction. I don't know whether, Hilke, you've got anything else to say about your experience of the court's oversight of cases.
I think the court's oversight is a difficulty because, I mean, particularly now, and I don't know, I haven't had a recent secure case or a deprivation of liberty case, so I don't know what it's now. But in the past, I think the President's guidance is really helpful because due to lack of court time, these cases could end up being rubber stamped for an extension and the overview, and sometimes they're very far away, and so therefore they don't get inspected as often. And so I think it's really helpful to have that guidance and to remind ourselves that it is there and that we should refer to it, because otherwise it's not a secure placement that has the same statutory framework and the same timelines as any order made under Section 25.
Absolutely, and I think that before Section 25, and when you look at what was happening before Section 25, there was an interesting report in the early 90s about children's deprivation of liberty before the court's authorisation under Section 25, and that was called. I was looking at it's called Pin Down. And when you look at what was happening before we had this statutory regime, you can see why the regulations and the statutory framework is so tight, because of the concerns of what was in place beforehand. And I think the danger that we face now is that because of this chronic shortage of placements, we are effectively running a separate scheme, and that's been the inherent jurisdiction, and the availability of the inherent jurisdiction to authorise those placements is allowing that, and that's the difficulty. And because of the nature of the children who find themselves in these placements, it means that they are not being afforded the level of care often that they really need for them to be able to move back into placements which do not have such a high level of restriction of their liberty. Because the secure accommodation, when it works, can provide a breathing space and the opportunity for children to engage in work, including therapy, and address some of the issues that they were finding difficult in other placements, in order for them to eventually to move on and to find themselves living a less restricted life and less managed by the local authority.
I think Amanda has something to contribute.
Yeah, so I wanted to touch on some practical reasons why we have the situation we have. So
should I stop my screen share now, because I've come to the end of my slides?
Well, have you? Oh, I didn't want to cut you off, because I think you might.
No, that's
yeah.
That's the end. That was good timing, Amanda. That was great timing, even though we're not in the same place.
Okay, so before I go onto my slides, I wanted to set up what appears to be the sort of underlying problem about the lack of there being sufficient placement. So on the one hand, because it's not just about quantity, and I'm going to explain why. So first of all, and I think that this is a point that the ALC made recently in their submissions in the Supreme Court in the T case. We don't have judgment on that yet. It was only heard a couple of weeks ago. But the ALC made this point very strongly, and that is that the types of secure accommodation that private providers provide haven't kept up with the huge strides forward made in child-centred care planning. And we've moved from a position where it's expected that a child should fit into whatever secure accommodation is available, to placements being tailored to the needs of the particular child. And May said this right, we're dealing here with the very most vulnerable children and young people in society. So there's a sort of a mismatch between the idea behind secure accommodation, which is that the provision of, just looking at the definition in the secure accommodation regs, the definition is accommodation which is provided for the purpose of restricting the liberty of children, to whom Section 25 applies. Now, really, as far as care planning and bespoke solutions for very troubled children, and not just the problems that the children themselves have, but the problems that society, that the current conditions in society have created, such as county lines issues, which present terrible problems for local authorities in seeking to meet children's needs who are subject to that form of exploitation. And also trafficking for sexual exploitation, the self-harming behaviours, the sorts of complex needs that face local authorities in the delivery of their duties to children to safeguard and protect their welfare. And then, of course, you've got the expansion of the child-centred principles of the UN Convention on the Rights of the Child, and the importance of the voice of the child, and the sort of quite sophisticated shift in attitudes and principles affecting care planning. And then, of course, you've got the individual child's human rights as well, which possibly weren't in such sharp contemplation at the time of the drafting of the 1989 Act provisions in respect of secure accommodation. As May rightly said, they were very much focused on what was perceived of the problems of the time in the existing system. So all those elements, I would suggest, make the secure accommodation, the statutory framework, ill-suited to deal with the modern principles applied to protection of children and young people and safeguarding and promoting their welfare. Because we remember, obviously, that in lots of care planning, you won't be dealing with the sorts of needs which are going to be assisted by containment, by physical containment. What you need is authority, and where it's under the inherent jurisdiction in the authority of the court. What you're looking for is a means of building into care planning authorization to restrict liberty in the event that it's required. And that might be physical intervention, or it might be other forms of restriction on liberty. It might not always be about physically where the young child or young person is, but what the child or young person does, and access to internet and things like that, access to forms of access to harm, access to sources of harm. So again, that's another reason why simply having more secure accommodation as it's currently understood, and I think that anyone who's been to a place of secure accommodation will be familiar with the quite punitive, quite how did Hayden J describe it? I forget the word he used, but he used a form of expression in a recent judgment that made it clear that the environment in secure accommodation, possibly with its emphasis on containment and its relatively institutionalized nature, may not be in the interests of the individual child with complex needs. So that's a kind of a sort of an overarching problem. But there's another overarching problem, and that is the way that the distribution of secure accommodation places is set up currently. So whereas local authorities bear the burden under the Children Act to make sufficient provision for accommodation for children in need within its area. And that's a general duty, and it's a sufficiency duty which is aimed at accommodation generally, not specifically at secure accommodation. However, once that secure accommodation is commissioned and a placement is available, and I'm talking about a provision rather than a specific placement. So once there is, say, a provider in the local authority's area, say, that local authority, because of the way that the placements, secure accommodation placements are for welfare are allocated, there is no way that a local authority can ring fence those places. So they are all allocated under a national hub, which is administered by the Department of Education. And I think what the recent cases have thrown up, and in particular the Children's Commissioner's recent report on deprivation of liberty of children and young people, and the relatively unregulated way it seems to be occurring. You've already gone over that. I won't go over that, my fellow speakers. But it's clear that the problem as regards provision of secure accommodation is that whereas accommodation is allocated nationally, the bodies that allocate that accommodation don't appear to be putting sufficient resources. There's no means of the central government, or the centralised way in which those allocations are handled is keeping up with need, not just in the numbers of places needed, but in the type of places needed. So that's kind of quite a long-winded way of saying that underlying this anxiety about the availability of places is a very structural problem, which arises from the legislation, but also from the system of allocation which is currently administered. So I don't know, May or Hilke, whether that you've got anything arising from that before I go into sort of the consistency with the Article 5 principles.
Just did you want to say something, Hilke?
Yeah, I mean, I just thought it was a really interesting, and it's such an obvious point you made about the ills the Section 25 was designed to address back in 1989 and what we're now dealing with. And I've been often wondering whether secure accommodation is the resolution to a problem, because in my experience, most children who are young people who end up in secures come out and go back to their old way of life, whether that's 3 months or 6 months in secure, depending on what happens. Quite a few of them I've been involved with were on the autistic spectrum and were therefore but highly functioning, so highly vulnerable, and at the same time in need of a specific approach, and locking up wasn't the specific approach that worked for their particular needs. And what I've also come across is that if you have a good system of highly experienced, well-trained foster care placements, which have maybe a level of restriction that and have a therapeutic element to them, that this may be another way of dealing with it. But I think it is an expensive system to run, And it needs a rethinking of the whole system, because I'm not quite sure. It's a bit like a prison reform thing, really, because it's like, why do you lock these young people up? Do you, yes, to keep them safe, but that doesn't mean that when they come out, they're going to be safe all of a sudden, because it goes along with a whole lifestyle and education. And while secure units have some therapeutic input, from my experience, it's a very expensive way of keeping a child locked up for a number of months without any long-term benefit, and so maybe the whole system needs an overhaul. But I'm just not quite sure whether this particular seminar is there. But to start the conversation going in terms of what are we trying to achieve? Ultimately, we're trying to achieve to make very vulnerable young people less vulnerable and more able to re-enter mainstream education, mainstream life. And I'm just not convinced that the current system works in that respect. And in a way, then the inherent jurisdiction becomes a plaster, but also gives the opportunity to think more creatively about the individual needs of a child, and cater the placement towards that child with a wraparound service and the ability to ensure that they stay put.
Thanks very much. Right, so Hilke, so I'm going to try to share my screen now.
While you're doing that, Amanda, should I just come back on the things that you were just had a couple of points on the points that you made?
Sure.
I set it up. But I think firstly, in respect of the allocation of resources, I mean, certainly in the cases that I've done, there have been beds available in secure accommodation, but they've not been allocated to welfare. They've been allocated to the Ministry of Justice in terms of young offenders. So there was space, but it just wasn't allocated to the right resource. Secondly, in terms of reform, I think you're absolutely right in terms of locking people up. That's not necessarily as Hilke was saying, in terms of sort of prison reform, in terms of locking people up, is not always an answer to solving the problems that young people present with. But the issue I've found with placements that have been authorised under the inherent jurisdiction is that young people are not getting a sort of bespoke placement. What they're getting is containment and restriction, and that's not meeting their needs at all. And then thirdly, in terms of reform, I mean, and if we could talk about that now, we can talk about it at the end, but a way forward would be to amendment of the regulations to allow the Secretary of State to approve community placements, which would much more be in line with what you were talking about, which would allow more, and Hilke was saying, which would allow these more bespoke placements, which really did meet the needs of the child, and they could be, the Secretary of State could approve them as secure accommodation in community homes, which would mean that and that would only mean an amendment of the regulations, because it's the regulations that provide for the Secretary of State to approve secure accommodation. But perhaps we can talk about that a bit more.
And yeah, and that would certainly meet the foreseeability requirement of Article 5 that I'm about to come on to.
Before you go on to it, I've just seen there's a question from Bethan Harris saying, is RETI significant to our understanding, and now the question's gone, of the components of a deprivation of liberty? I think that's for Mai-Ling.
Well, I don't know if Amanda's going to deal with that, actually. Are you going to deal with that?
Oh, I was going to go into that.
Okay, then we'll leave it at...
Yeah.
Bethan will deal with that in just a minute.
I think just sort of headlining what I'm going to be saying, I think RETI is important because it in understanding there's a mismatch between how the Stork criteria are being applied in the UK context and what the obligations are to protect children from serious harm. So I'm going to try and load up my screen now. Yes, we've already seen that. So hang on a minute. right, there we go. Can everybody see that? May, can you see my screen? I now can't hear anyone.
Yes, it's visible.
Okay, great. Thanks very much. Okay, so just another bit more judicial deprecation there. So I'm going to talk a little bit now about just outlining the Article 5, the aims and purpose of Article 5 and the criteria for a deprivation of liberty as they've been applied in the UK context. So just so for everyone to see there, you've got the Article 5.1 and the particular points I wanted to highlight from the article are that in Article 5.1 provides that everyone has the right to liberty and security of the person. No one shall be deprived of his liberty save in the following cases, I'll come to those, and in accordance with the procedure prescribed by law. And in Re T, one of the issues which is particularly important was whether the inherent jurisdiction process was sufficiently certain and foreseeable and had sufficient protection against arbitrariness in order to qualify as a procedure prescribed by law. I'm going to come on to that in a little bit more detail, but just so that you understand where I'm going with this, I'm going to be suggesting that, in fact, the inherent jurisdiction process, particularly as set out in the President's guidance and in the dicta of Lord Justice Baker in Re B, is actually more compliant with the Article 5 requirements that deprivation of liberty be in accordance with the procedure prescribed by law than necessarily the secure accommodation provisions. And that's because, as we've sort of highlighted during May and Hilke's talk, the inherent jurisdiction process is able to be more nuanced. The restrictions are able to be tailored to the needs of the child. So, for instance, those of you who are familiar with the concept of step-down accommodation, and Hilke was saying recently that it's not unusual in her experience for children to go back to the same harmful behaviours and harmful circumstances when leaving secure accommodation as before. There is no concept of step-down accommodation within the secure accommodation provisions and within the framework, but that by contrast, I'm going to be suggesting that the inherent jurisdiction does allow for that nuanced, proportionate approach, and for there to be no more restrictions on liberty than the specific particular child requires, and that taken with the President's guidance, which allows for court oversight of the use of the placement, is sufficiently foreseeable to be a procedure prescribed by law, because the procedure prescribed by law, as it's understood in the context of Article 5, isn't just about statute law. It also extends to common law in a common law jurisdiction, and in certain circumstances, international law. So we're here concerned in the context of secure accommodation with Article 5.1d, the detention of a minor by lawful order for the purpose of educational supervision, or his lawful detention for the purpose of bringing him before the competent legal authority. And so if we can just scroll down to have a look at what that justification Article 5.1d means. So we can see that a bit of flesh on the bones of how Article 5.1d has been understood. And particularly, I wanted to draw attention to the context of detention of minors. The words educators, fourth paragraph down, educational supervision must not be equated rigidly with the notions of classroom teaching, but include the exercise of parental rights for the benefit and protection of the person concerned. Now, the problem there is, in the context of depriving a child of the liberty via the inherent jurisdiction on the application of a local authority, is that, of course, a local authority may have a parental or quasi-parental responsibility in respect of a child, certainly in respect of a child who's subject to a care order. But as a manifestation of the state, the state cannot authorise its own deprivation of a child's liberty, even where they are seeking to exercise what would be a quasi-parental role. So just going back to Section 25 of the Children Act, the current position is that following the ruling of the Court of Appeal in what's also known as Re K, the court had rejected a complaint that Section 25 was incompatible with Article 5, because the court in that case, following a case called Koniarski, I'll come to in a second, held that restrictive measures imposed on young children within the zone of parental responsibility would not normally be a deprivation of liberty, and that the purpose of the Section 25 regime, as set out in the regulations, was to restrict the liberty of the child, but is a benign jurisdiction to protect the child as well as others. What about the question of what is a deprivation of liberty? So we're here concerned with three elements in order for there to be a deprivation of liberty. And it's important to recall at this stage what the purpose is of identifying these three elements, and what the purpose is of identifying when something amounts to a deprivation of liberty. It's for this purpose, which is to trigger the requirement for the procedural safeguards and the limits on deprivation of liberty imposed by Article 5. If I can put that again, in the context of a child's situation, it means that there is a potential for a conflict between circumstances where a child considers that they are able to, because they have a certain degree of competence or maturity, to express consent in respect of restrictions on their liberty, but by doing so can potentially be triggering a situation where they discount themselves from the availability of those procedural safeguards. And that's exactly the situation that arose in T, where T was a young person aged 15 who wished to be able to consent to a proposed care plan, including what everyone agreed at the time were deprivations of her liberty, but the court rejected that consent. But the question then was, even if that consent had been given, the consequence would have been that the court would have to think about whether or not it was proportionate to make that order. But what would be the consequences for a young person who had consented to the order and the restrictions were nevertheless applied? they didn't amount to a deprivation of liberty for the purposes of triggering the Article 5 safeguards set out here and referred to as the Stork formula, then that would effectively mean that it was a means of effectively contracting out of the court's supervision of the supervision and control exercised over that child by the local authority, which is quite a difficult concept. It's a difficult and troubling concept, the idea that a young person, by consenting to a deprivation of liberty or restrictions of liberty amounting to that, to a deprivation within the terms of a care plan, could, by consenting, be effectively removing her circumstances from those in which the court would normally exercise supervision about the proportionality and necessity of the application of those safeguards to that child. And that's problematic in the context of the use of the inherent jurisdiction, because of course, in the context of Section 25 accommodation, that statutory framework, which has been found to be Article 5 compliant, does not require consent. There is no part, May's taken you through the Section 25, it's quite clear from Section 25 that consent just doesn't feature. And obviously there's a reason for that. If you have a statutory provision, the aim of which is to protect the child effectively, then whether or not that child consents to that protective measure, where the state is under a duty to protect that child, we can see why Parliament wouldn't have thought at the time that it was necessary at all. Of course, having had the benefit of looking at Baker J's, Lord Justice Baker's careful analysis about the interplay between the two schemes in Re B, we know that that gives rise to a number of difficult questions and potentially a head-on conflict. So just looking again at the concept of consent, because there's plenty of authority in the Strasbourg context for the concept of the importance of consent, and that those of you who are familiar with the operation of the Mental Capacity Act will know that under the Mental Capacity Act, there's quite a sophisticated and nuanced approach to the circumstances in which a person can be found not to have capacity to consent. And the idea of an informed or capacitous consent is something which is very specific. It's limited in time. It has a very a nuanced context. It's specific to the particular decision under issue. But by contrast, in the context of decisions taken by under 18s, particularly under 16s, in the family court proceedings, we're dealing with a much more broad brush approach to the idea of consent, which is Gillick competence. Now, obviously, I'm not a family law expert, and I'm sure May might have something to say about this, also Hilke. But my understanding of the approach to Gillick competence is effectively there's a broad brush decision made about whether a child is basically able to make decisions about matters concerning herself. Gillick obviously was a case about access to medical treatment and whether parents were required to be informed or whether children could give instructions or give make their decisions to the doctors directly. By contrast, we're dealing with a completely different circumstance in the context of consent to deprivation of liberty. We're talking about the circumstances, as I say, in which a child might effectively be able to contract themselves out of the procedural safeguards provided by Article 5. and query, and I'm raising this as a question, I'd like to hear what other people have to say about it, query the extent to which Gillick competence, as currently understood in family practice, is really apt to address the kind of consent which might be able to influence decisions on making deprivations of liberty orders. And I say that might be able to influence because whereas as it currently stands, certainly in RET, no argument was being raised to say that in the context of certainly of a 15-year-old child, that that consent could effectively denude the court of jurisdiction to make a deprivation of liberty order. Nevertheless, it's quite clear that the general consensus, both the Court of Appeal in RET and also in many of the parties who made submissions in the recent case in the Supreme Court, same case at RET, was that it of course has a role to play in the exercise of discretion whether to make a deprivation of liberty order, and that is first of all, if the child gives a valid consent and the court accepts that the child intends to be compliant with restrictions in the care plan, then is there any need to make an order? Is it necessary to make an order? And is it proportionate to make an order? And what order is it proportionate to make where the court accepts that the child genuinely and validly agrees to be compliant with the care plan? So there you've just got some information about the principles which apply to when a procedure is prescribed by law. The key an underlying principle of Article 5 is really helpfully summarised there in a quote from both the Bournewood case and Stanev, and that is that the key principle is the duty to operate a system which prevents arbitrary deprivations of liberty. So in this context, the concern is, and the anxiety is, that whereas the statutory scheme for a deprivation of liberty by under Section 25 of the Children Act is relatively straightforward and clear, by contrast, the nexus between the need to detain and the underlying reasons for it, i.e. the complex needs of the child, isn't so clear. And so there is a real sense in which the ability to tailor and nuance and child centre care planning under the inherent jurisdiction in a way which is more specific and more aimed at the underlying reasons for the serious harm. The ability to do that effectively renders on one analysis, I'm just putting it out there, the inherent jurisdiction process less arbitrary than the secure accommodation process. So here we can see the Koniarska case, which is now quite old. It's from 2000, dealing with the Section 25, whether it's compliant with Strasbourg authority. I'm wondering whether if Strasbourg were faced with the detention of a young person with complex needs in what we all understand to be Section 25 secure accommodation, i.e. under lock and key in that quite punitive environment, I'm wondering whether faced with those circumstances again, even if education was being provided, whether the Strasbourg court would be so confident in the current climate, bearing in mind, of course, that following the principle of Mai-Ling in the Strasbourg court, we're also very concerned to ensure that international law, insofar as it, and treaties, insofar as it has a bearing on the article under consideration, has to be construed consistently and to be taken into account when looking at the scope of the obligations under Article 5. So, for instance, the need to the importance of the voice of the child under Article 12, the best interests of the child under Article 3.1, even though those provisions aren't actually incorporated within English law. They are under the Welsh system, and they are shortly to be, I understand, in the Scottish system. It seems to me that a Strasbourg court, faced with the circumstances in which a child with very complex welfare needs ends up in Section 25 secure accommodation, might be troubled by the lack of nexus and the arbitrariness of putting a young person whose needs aren't specifically to be under lock and key, but rather to be protected from particular forms of harm in less restrictive ways. And again, harking back to the general principle of the Mental Capacity Act here, one of the key principles is that any deprivation of liberty has to be the least restrictive measure, and if measures less than the deprivation of liberty can afford a proportionate benefit, then that should be preferred. So I know I've dealt with some of these matters in when responding to May and Hilke's talk. I wanted to leave 15 minutes to discuss questions, so I'll shortly draw to an end. But I just wanted to make sure that the key point I'm trying to make is understood. We have a circumstance in the use of Section 25 accommodation where there are very practical and principled reasons why the use of secure accommodation for children who have welfare needs, so that's to say apart from the criminal justice system, is arguably not in itself not in conformity with Article 5. That the reasons why the Strasbourg court in Koniarski considered that the Section 25 framework was sufficient to meet with the requirements of Article 5 are vulnerable in the current climate, and that the mere fact of central government oversight by means of Ofsted or by means of the CQC of registered accommodation, or by the Secretary of State, so the former in the case of children's homes, the latter in the case of secure accommodation, is, in my view, insufficient to answer the both the systemic and the principled issues raised by the use of secure accommodation, and that the best, in fact, the most efficient and most child-centered way of ensuring that deprivations of liberty are in accordance with a procedure prescribed by law and are necessary and proportionate is for in the individual case rather than in the generic provision of accommodation, but in the individual case for a court to review on a principled basis the appropriateness of a placement. And that means, and I come down to state this quite boldly, that there are going to be children where it's in their best interest to place them in unregulated provision if a court is satisfied that the arrangements are appropriate, and that it will not be in the best interests of a child to go into secure accommodation because that accommodation, although it's available, isn't able to meet that child's needs. So at this stage, we've got 15 minutes for questions. I'm going to come out of my PowerPoint shortly, but I've put some questions up there to get people going if people hadn't put forward their own questions. I'm going to ask May now, who's probably had an opportunity to look at the questions while I've been giving this talk, whether there's some questions coming in that we can deal with.
Oh. Did I haven't. I've unmuted myself, but I'm not sharing my screen with you, am I? Have I accidentally shared my screen? No.
I'm going to unshare my screen now.
Oh, it's your screen.
Yeah, my screen has got the questions on though.
Oh, okay, fine.
Should we keep it?
In terms of questions, we've got a comment from Stephen Simlett QC, just saying Emmanuel, lack of nexus points, presumably also supported by Romans and Belgium.
Yes.
Right.
Yes. No. Absolutely. I mean, absolutely. I mean, that's a really interesting case because in that case, it concerned the deprivation of liberty of an adult for the purposes of receiving psychiatric treatment. But interestingly, the person wasn't able to access any of the treatment that he was in detention for because they hadn't provided an interpreter or somebody who was capable of providing therapeutic engagement in his own language. And so he just sort of rattled around in detention.
Very thorough care planning.
No, exactly. So Stephen's spot on. That is exactly the sort of lack of nexus that I'm talking about.
And then we've also got a question from Denise Lister asking about the experience of whether or not actually the inherent jurisdiction is more nuanced and tailored and therefore positive rather than a negative. And then secondly, has anyone had the use of the inherent jurisdiction in these circumstances for to prevent radicalisation? I mean, coming back on that, the point that Amanda's making about the inherent jurisdiction actually providing a more nuanced and child-centred care plan, I think that could well be right, but in my experience, that's not what's happening. Is that it's really it's holding. It's not providing anything. It's just the restriction. And I think that's right. I think that we have to move, as I was saying, I think we have to move to a situation whereby or one possible way of reforming the situation is to allow the Secretary of State to, on a case-by-case basis, authorise, say, community homes or other placements as secure accommodation. But what we've got at the moment is a situation where I think applications under the inherent jurisdiction are being brought as a sort of last resort where no other accommodation is available, and it is these types of tents, narrowboats, hotel rooms, holiday lets that are being authorised, and it's not the nuanced care plan. I think that if that was a way forward and local authorities were using it in that way, I think that it would have to be for the sort of tiniest minority of cases. I think firstly because it's extremely expensive way of doing it, and secondly it's putting an onus on the courts already stretched resources to monitor cases on this case-by-case basis, because you don't have the statutory scheme, they have to be scrutinised in an extremely careful way, and that all the care planning has to be micromanaged by the court to make it these type of nuanced care plans. So I think that, yes, in the sort of tiniest minority of cases, but you can't have what we seem to be having now, which is a whole sort of subset of cases running alongside the statutory scheme. But I totally take on board Amanda's point that that's the child-centred way forward.
But maybe, do you think it would be, it makes that much difference to the court, because you have to apply to the court for a Section 25 order anyway, and the court has to be satisfied in respect of the statutory criteria, which are the same as the court's currently applying in the inherent jurisdiction. Plus, following Baker J's guidance, the court has written into the Section 25 analysis a requirement for proportionality, necessity, and for and the voice of the child, wishes and feelings. I mean, the whole welfare checklist hasn't gone in, but it's certainly much more of a nuanced evaluation under Section 25 in the light of the recent jurisprudence than it was, say, I don't know, five odd years ago.
I guess the applicability of Section 25 still limited to the approved placements that have a more broad brush approach, and I think maybe that's a discussion that comes out of RET and out of the other discussions that flow from it, and rather than seeing the inherent jurisdiction as something that is just a plaster to deal with the lack of secure accommodations, to actually have it as a positive contribution to that system and food for thought as to how things can be approached differently to actually achieve something more longer term.
So certainly the development of more varied forms of secure accommodation.
Yes, which could be done if the Secretary of State was allowed to approve other placements. Yeah,
I agree with what you say about amendments to the regulations being a potential way forward.
But I think that, I think I would have to say that I think it is more onerous in the sense that when you've already got an inspection regime that monitors the staff and the placement, if the court then has to take on that additional responsibility of ensuring that the members of staff are suitably qualified, suitably trained, I think just in my experience, it just is, it's a restrictive regime rather than one that's really providing something that's particularly tailor-made. But that might be just my experience. I don't know, perhaps has anyone got any experience of, can anyone share their experiences of perhaps a better outcome for children when applications being made under the inherent jurisdiction? But shall we look at your questions, Amanda? We've got 8 minutes left.
Yeah, I was just looking at the Q&A list to see what we've got there. We've got, did you see there Denise Lester's?
Yes, that was a question we were just,
okay.
And then there's a new one that's just come in. Am I right in saying that the court would have had to have read into the proportionality requirement because of the HRA, and it doing so has nothing to do with the inherent jurisdiction?
That's right. Well, it's both. So yeah. You've got the HRA, but under the exercise of the inherent jurisdiction, they're concerned with an order depriving of liberty. So automatically that would be it would have to be Article 5 compliant, because that's the ballpark that you're in. But I agree, it's also arises as a consequence of the HRA, so that you're going to be, as a public authority, under an obligation to have all the regard to all the relevant rights, including Article 8.
Amanda, what you were saying, just picking up on one of the questions that you sort of positive about Gillick competence, I wondered whether Helke had anything to add about in terms of looking at, in terms of alternative sort of tests of capacity and competence.
I mean, I think there's
solicitor.
Yeah, there's always this kind of, I don't know, this tension is not the right word, but there is the Gillick competence, and it's the right to make decisions in relation to yourself and depending on your age, and Amanda said that out. But then there's also, because what comes within, it's like within Section 25 applications, children are always represented, and it is a requirement, and they get legal aid, and the same appears in the DOL applications. But then there's also other levels of capacity and competence, because it involves then also child's competence to instruct a solicitor directly, or whether it is there needs to be a buffer zone through a children's guardian, and that's a different assessment than the one that comes under the Mental Capacity Act, and also under the Gillick competence understanding in terms of law. So you basically you sometimes might have three types of capacity stroke competence in relation to a child that is a party to one of those applications, and their input and how their voice is being heard, and whether it is through a children's guardian. Because if there may be understanding what's going on, they may have a very clear view of that they don't want to go to a restricted liberty placement, but at the same time they may not emotionally be able to engage in the proceedings, and that's different from the Mental Capacity Act, and that's different from Gillick competence. So I think there are three levels of competence and capacity that might potentially play into any of those, and that's not necessarily something to do with age. It's to do with the difficulties a young person has.
I don't know, Amanda, whether you had anything to add to that in terms of, I mean, did you want to say anything in response to that?
No, I mean, I think that it's inescapable that we've got a very obvious practical problem which is capable of a solution. And the obvious practical problem, at least on quantity of secure accommodation, is to put central government together with local authorities to come up with more proposals as to different kinds of secure accommodation all over the country. And making some thought to go into how much accommodation there is spread across the country, because one of the problems about having the obligation to make sufficient accommodation available lying on the individual local authority, but the distribution to be in the hands of a central body, is that it's easy for there to be to take your eye off the ball about what you need, what kind of accommodation you need in what part of the country.
Absolutely.
Some local authorities might only make 1 or 2 inherent jurisdiction applications a year, and other authorities might have a lot more. But that's just going to mean that there's more pressure on them to find placements.
Yeah, absolutely. We've just got a couple more questions. One from Julia Horn, just saying, it sounds like the panel is suggesting that this is a topic for research. I think there certainly needs to be more.
I certainly think that the Supreme Court giving their attention to this vexed problem is likely to result in a certain amount of galvanization.
Absolutely. And then another one saying, so the case you're making for the inherent jurisdiction is a non sequitur if you agree with me that the HRA requires proportionality regardless.
I suppose I was saying that's actually kind of what I was saying, where the development in the jurisprudence as to the approach which the judges are saying has to be taken to the making of Section 25 orders is definitely reducing the difference in process, the difference in analysis, certainly within the making of the orders between the inherent jurisdiction and the Section 25. So the task is the same. But as May pointed out, one of the big differences is just because you meet the requirement for a Section 25 order, if you have a child or young person that meets the requirement for a Section 25 order, it does not mean that the kind of accommodation that you would then provide as a consequence would be secure accommodation, i.e. accommodation provided for the purpose of restricting the liberty of the child or young person. It's important to recognise that that's what Section 25 accommodation is. It's where the main or only purpose of the accommodation is to restrict liberty. By contrast, as May explained, children's community homes could be a whole lot different, and it wouldn't be necessarily right to describe those forms of accommodation as accommodation for that purpose.
And then just finally, the last question, how far can the restrictions of a dole order go without becoming unlawful under Article 5, e.g. what restrictions are allowed and what's not? So I suppose in identifying the sort of placements, I mean, I think it's quite helpful in Re-S. Cobb sets out, and won't take you through it, but Cobb sets out the type of, I just looked it up here, the type of issues, and they were, and I think that's one of the interesting things about the sort of interplay, and that occupied the courts a great deal in Re-D as to the sort of zone of parental responsibility, what was appropriate in terms of what is a restriction of liberty for a young person, as opposed to the slightly more, what's set out in the Mental Capacity Act about what's a restriction of liberty for an adult. And I think that's, if you, in reading Re-D, you'll see what the issues are in respect of restrictions in terms of age, and Mumby sets that out as well in terms of the age of a child. But as I say, in Re-S, I did have it up here, hold on, where's it gone? Bear with me just a second. So in Re-S, the sort of hallmarks to identify the sort of restriction of liberty, S wasn't allowed to leave the placement without supervision and agreement. It's very much like the sort of adult test, really. Do you agree, Amanda, in terms of the amount of restriction? She's under constant supervision and control, at least one member of up to 2 members of the staff required, supervised at night. She was not allowed to go into the kitchen unsupervised. She was not allowed access to cutlery, metal cutlery and glassware and kitchenware. Staff at the placement were permitted to use reasonable force to ensure that she stuck to the care plan, and that staff in the placement were permitted to remove any items which could cause the child harm, or which you could use to harm others. So I suppose it's about looking at each of those factors and identifying whether in total they amount to restriction of deprivation of liberty.
There's a point I'd like to make here, and it's about what I think is again a mismatch between how deprivations of liberty work in the context of care planning and what the Stalk 3 criteria are. Because if it's constant supervision and control by the state with an absence of valid consent, okay, that's basically the ingredients of a deprivation of liberty. And the purpose for triggering for those 3 ingredients is to identify the circumstance where there has to be a body other than the state with a procedure prescribed by law overseeing all the Article 5 restrictions on the exercise of that supervision and control are met. And that's important. But one of the problems about that formulation, as it were, is that it doesn't really recognise the circumstances where the authorisation for a deprivation of liberty in the context of the use of the inherent jurisdiction, the authorisation being sought isn't necessarily to contain a young person or even to put them under supervision and control. It's to meet the point at which they are non-compliant with the care plan and to be able to have an authorisation to restrict liberty at that point. And that's a key difference. And I don't think that the Stalk criteria are apt to address that context.
Yeah,
no, that's very helpful. Hilke, did you want to say anything finally?
No, I just that I absolutely agree with what Amanda just said. That it's the Section 25 point is an overarching deprivation of liberty, but actually, what the purpose of it is, in the majority of care cases or cases that come to the attention where it goes towards young people in the civil context, is that the local authorities want them to comply with the care plan. And it's only at the point when they don't, or when they want to abscond, that would step in. It doesn't require a complete deprivation of liberty, and how that interacts with the Stork principles and Article 5. That's really an interesting point to develop.
And I think that in Mumby and AF as well is an interesting one to read about that, with the interface with care proceedings. Yeah. And that's important judgment to read, because he deals a lot with the interaction with care proceedings. I think AF is a good case to read for that as well. Well, right. Thank you very much. We got to past 2:30 now. Thank you very much for giving up your precious lunch times to join the discussion. It's been certainly a very interesting topic, and very one that's very relevant at the moment.
And the slides will be available. I don't know whether the recording will be available as well, because somebody asked about that.
I think we put it up on the website. I think there's be a link to it on the website, is what we usually do with webinars. So it will be available. Well, thank you very much.
Thank you.
Thanks everybody for attending, and thank you, May and Hilke, as always, because it's an education for me every time I do any presentation with you, May.
Well, thank you, Amanda. That's very kind of you. But thank you, Amanda, for sharing all the expertise that you've clearly been keeping the Supreme Court occupied with recently.
Right, so on that note then.
Thank you, and goodbye.
Thanks, everybody.